Realtors. Welcome back to another episode of Legal Breakdown in our mini series called Disclosure, Duties, and Dilemmas. George, what's our disclosure, duties, and dilemmas topic we're going to talk about today?
Gabe, a very interesting one that affects a lot of agents out there, and one that agents need to be made aware of.
Yes.
Okay.
Yes.
And that is the disclosure of licensee's interest.
Yep.
Acting as principal and status as a licensee.
Okay.
All right, and again, that's Iowa Administrative Code 193E.
Okay.
They can find that requirement there, the duty to disclose any interest that licensee may have in a transaction.
And again, that's in 193E, Chapter 7.8.
Yes.
And George, I want to read just a little bit from the code here, what we're talking about, because when we're talking about interest that a licensee might have, right, what the law says is a licensee shall not act in a transaction on the licensee's own behalf, right, or on behalf of their immediate family. What does that mean? It means at least including but not limited to a spouse, parent, child, grandparent, grandchild, brother or sister, on behalf of the brokerage they work for, or on behalf of any organization or a business entity in which the licensee has an interest, including an affiliated business arrangement, unless the licensee provides written disclosure of that interest to all parties to the transaction, right?
Right.
That's very important.
It's very important. And reading that, Gabe, common sense pops up.
Yes.
It seems to me to be common sense that you have any involvement, any interest, any relationship into an entity that is selling or buying. I mean,
Yep.
Common sense best practices tells you disclose it.
Absolutely. Now, you have to make that disclosure prior to providing any type of specific assistance in a transaction.
Exactly.
Right.
And that disclosure must be in writing.
Must be in writing.
Okay. Make sure it's in writing.
And the commission is also going to make sure if something goes wrong, if they're ever vetting a file or if they're ever, doing an audit, they're going to want to make sure that this disclosure was made and it was made properly. But George, if I'm representing a buyer that happens to be a family member, I just make that disclosure, right?
Very simple. It doesn't have to be a real detailed disclosure. Just something. A listing agent is, related to seller.
Yeah.
Listing agent is daughter-in-law to seller.
Is the other party really going to care? I mean, is this even that big of a deal? I mean, why not just not even think about this and just make the disclosure, even if it's close?
Well, I don't know why an agent, I cannot think of a good reason why an agent would not disclose.
Right.
And I will tell you this, my experience tells me that buyer is not going to care.
Yes.
Right?
Yeah.
That seller is not going to care.
I don't think so either.
Right. However, I will tell you this, that if they don't disclose,
Yes.
and the seller or buyer find out that there was a failure to disclose, that's when they're going to care.
They're going to care.
And then now they're going to start questioning everything you've done up to that point and everything that you do beyond that.
I think that's spot on. At the time, it might not seem like that big of a deal, but you better believe it's going to become one of the primary concerns if something else goes wrong. The other thing to keep in mind is when it talks about acting as a principal, right? If you are selling your own home that you are the sole title holder of, right? You have to make a disclosure, no doubt about it. But the law also says you shall not act in a transaction even if you have an indirect interest, right?
Right.
So, if I'm a member of the Iowa Association of Realtors and the Iowa Association of Realtors is going to sell their building and they ask me if I'm a licensee to sell the building for them, right? Should I disclose that I'm a member with an interest in the Iowa Association of Realtors?
Absolutely.
Somebody might make an argument, oh, you're a member of an 8,000 member organization, you're not really a significant interest holder. Why even have that fight, though? Just to make the disclosure.
One other question, Gabe, kind of a follow-up on that. What if you're a licensee and your license is inactive?
Yeah.
What effect does that have on your duty to disclose any relationship? Inactive license.
It's a great question, and if you're in that situation, you still have an affirmative duty, even if your license is on inactive status, to make that disclosure.
I think the law is clear on that.
Very clear. And George, I don't like to use the word common sense too much, but I think this topic, compared to many others in our disclosure series, is very intuitive, right? Just make the disclosure even if it's close.
Gabe, I'm going to end with this. Disclose, disclose, disclose. You can't go wrong.
Absolutely. And if you disclose, you'll avoid those disclosure dilemmas. We'll see you next time.